Our next case is LA Developers versus Department of Licensing and Regulatory Affairs. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. And you have time for rebuttal. We ask that you keep track of that yourself if we don't use it up, and you may begin whenever you're ready.
Good morning. May it please the court, Jonathan Koch on behalf of David Biker and LA Developers. When interpreting statutes, this court's job is to give effect to the plain language of the statute chosen by the legislature. Here, when it defined the term security for the purposes of MUSA, the legislature provided that a laundry list of items, including promissory notes, are securities unless context otherwise requires. The issue presented here is what is the test for determining whether context requires that a note is a security or not. We believe that the language of MUSA answers that question, and that the text of 2102C sub C Romanets 1 through 6 are the factors that control that analysis. I think there are two key pieces of statutory language that lead to that conclusion. The first is the all of the following apply to the term security. That language demonstrates the legislative intent that those are the factors that courts should look at when determining whether something is covered by MUSA or not. In light of that language, those factors aren't optional, and I point out that they don't include a catch-all or a blank check, if you will, that would allow the Bureau or courts to look beyond the language of the statute to other tests that might be appropriate. The other piece of language I want to highlight is the scope that limits the scope of the 5-factor test in Romanet 1, and that's that it applies to all contractual and quasi-contractual arrangements. That language doesn't slice and dice between enumerated or unenumerated instruments. It doesn't have limits within the category of contractual arrangement.
Counsel, what does the word includes mean then? I understand it says that it has to meet all the requirements, but it also says right before that, the term includes, which sounds like additive to me, like in addition to.
So I think that the term, when saying that it includes a contractual or quasi-contractual arrangement that satisfies those 5 factors, the implication is that it does not include a contractual or quasi-contractual arrangement that does not meet those 5 factors. And I think that that comports with the way these tests have been applied both within and outside of Michigan.
Wouldn't that be like from a pure statutory sort of construction and how we draft statutes? Like, wouldn't that sort of be up front? I mean, the way the statute's drafted, this is literally after a laundry list of instruments, and then this little subpart that says this includes. Like, does it feel odd that that would be like an afterthought, that we now have to run everything through this filter?
So let me just supplement that question. It's more than just it includes. It also has it does not include in another part. In another part it has may include.
So I think that the includes, may includes, doesn't include. I think those factors do different work, but I mean, I think that the fact that I think the context otherwise requires language is what necessitates kind of some of this filtering. If the statute just said security means notes, stocks, bonds, I think the 47 items in the laundry list, we wouldn't need tests or factors. It would just, is it a promissory note? If so, it's a security. But given the unless context otherwise requires, that requires some work, some digging beyond the surface, beyond the labels, to look at what is the nature of this transaction? Is it an investment? Is it a security? Or is it something else? And I think that the additional language that the legislature included is geared towards the determining whether context requires. And I think, to go back to your question and not to repeat myself, the basis for these tests that was codified by the legislature was judicially created tests created by federal courts for determining whether context otherwise requires that an instrument is a security under the Federal Act, which doesn't include this language. And so, given that those tests were used to both include and exclude instruments.
So what about Laura's argument that your argument, if everything got run through this filter, then several things that are on the list, which I think people definitely consider to be a security, like a bond, potentially maybe wouldn't be covered?
Two things. First, the five-factor test in Romanet 1 doesn't apply to the entire laundry list. It would only apply to instruments that are contractual or quasi-contractual. And so I haven't researched whether a bond or a stock are contractual, but there would be items in there that...
I think it's contractual.
Okay.
So.
And I think the other thing is, as we've seen from how both Michigan and federal courts come to this issue of determining whether something is a security, one of the general principles is we look beyond labels to the nature of the transaction. And so something that by its nature is not a security isn't regulated by MUSA just because they slapped a stock or bond label on it. By the inverse, just because we didn't label something a bond or a stock doesn't exclude it from MUSA's reach if its nature is that of a security.
What about, I think it was the securities, North American Securities Association administrators submitted an amicus brief, and they said that Reeves wouldn't really impact the instruments and the cases that you have relied upon for your argument. I mean, they're kind of like, it really doesn't make a difference. So why does it matter?
So I think it matters because we give effect to the words chosen by the legislature. Here, the legislature chose to include that language. It didn't have to. The Congress didn't, right? Congress just gave the laundry list, and unless context otherwise requires. So courts were free to paint on a blank canvas. They were free to come up with whatever test that they deemed appropriate. And I think you see that in Reeves. They didn't say, hey, the language of the 1934 Act, or the Federal Securities Act, they didn't say that the language of the Security Act compels this result. They said this is a more promising test. They looked at the family resemblance, risk capital, and common enterprise tests and picked the one that they felt was best. And they could do that because they were painting on a blank canvas. Here, that's not the case. This court, Michigan courts, aren't painting on a blank canvas because the legislature has expressly codified language for determining whether context otherwise requires. It is codified tests for determining whether something is a security into the language. And it's in fact given courts a menu. It can choose between the risk capital test in Romanet 1 or the common enterprise test in Romanet 5. I think if an instrument passes either of those, it's a security, even if it fails the other one. But the fact that the legislature gave you a menu of two doesn't allow you to go outside the statute and say, well, I have two options, therefore I can go choose a third. Does that answer your question?
Thank you, yes.
Are there any other questions? I will hit a few more points and then reserve the rest of my time for rebuttal. I want to highlight, I don't think that the Court of Appeals distinction between enumerated or unenumerated instances comports with the language of the statute. I think the Michigan case law culminating in Noyd is still good law because the language of the statute is materially similar as it applies to those factors. I think the inclusion of the common enterprise test in Romanet 5 doesn't negate that. And then the last thing I want to highlight is I'll call it the statutory history of MUSA relative to Reeves. So in 1979, the legislature codified the five-factor test in Musa. 10 years later, in Ansorge, the Court of Appeals applied that test and said, we read the expressly enumerated factors set forth in Musa to constitute the factors to be considered in determining the investment character of a transaction. Several years later, Reeves comes out, adopts the family resemblance test over the common enterprise and risk capital test, expressly says, though we're not applying those to notes. And then for the next 18 years, the legislature, the definition of security bounces around a little bit, but it leaves the risk capital factors in place. It doesn't codify family resemblance. It doesn't limit the scope of the five factors to investment contracts like the Wisconsin statute cited by the Bureau. And then in 2008, when the legislature kind of codifies the 2002 Uniform Act, not only does it retain unchanged the five factors, or materially unchanged the five factors, it adds in another test, the common enterprise test. So what we have is a statutory history where the legislature has time and again amended the statute without incorporating Reeves and retaining two tests that Reeves rejected. Given that development and the presence of Ansorge and Noyd, I think that the case law and statutory history of Musa compel or support the conclusion that the legislature did not intend the family resemblance test to control.
What do we do with, we had some experts, I would say, weigh in on this case. Amicus Business Law section, I think, disagrees with your position.
I think that's true.
Yes, so, they talked about the risk capital test, which is these factors that you're talking about, was never intended to apply to promissory notes. So, I assume your argument is we just have to go with the straight statutory language and ignore what the
You
plan
said
is.
it, so I don't have to.
Okay.
I mean, that is, again, I would refer back to the federal courts are painting on a blank canvas. Michigan courts are not. Any other questions? All right. I will reserve the rest of my time for rebuttal.
Good morning. May it please the court, Assistant Attorney General Aaron Levin, representing the Securities Administrator, and with me at council table is Solicitor General Ann Sherman. This court should deny leave for two main reasons. The decision of the Court of Appeals is supported by the plain language of the Securities Act, and it offers the most robust protection for investors in Michigan. The best reading of the statute gives every word meaning and considers the context and placement of each word within the statutory scheme. In this case, that means understanding the risk capital test to supplement rather than limit the list of enumerated instruments. This is clear from the legislature's use of the expansive includes, which stands in contrast to its use of does not include in the same subsection, as well as its placement of the test at the end of the list. Appellant's interpretation, on the other hand, elevates the risk capital test above the list of which it is a part and requires that each enumerated instrument be filtered through this test. This negates the list of enumerated instruments and would make Michigan an outlier among state and federal securities regulators. It would also be harmful for Michigan investors because it would exempt from regulation some of the most common securities transactions, including those on the secondary market and those promising a fixed rate of return. And exempting securities with a fixed rate of return is especially troubling because that includes some of the specifically enumerated items, and it also includes some of the most common schemes against which the Bureau takes enforcement action, which would leave many of Michigan's most vulnerable investors without recourse or protection. Because the legislature mandated that the Securities Administrator maximize uniformity between state and federal securities regulation, this can't be the correct result. Instead, the best reading of the statute interprets the definition of security broadly and flexibly in order to offer the best protection for investors in Michigan. So starting with the language at the beginning of the statute, it begins with, unless context otherwise requires, and then it moves into a number of definitions, including the definition of security. So that language controls the rest of the statute. If the legislature had intended all of the following to be controlling on context, it could have placed that first. This is in a definition section. It could have said context means, and it could have defined that. If it had intended every contractual arrangement to be filtered through this test.
Counsel, good morning, and you're doing an excellent job. I just have a question, though. If the court were to rule against the state in this matter, what would the implications be? I mean, you kind of glossed over it. It was a very interesting point. Can you tell us a little bit more about what those implications would ultimately be for people here in Michigan and for the course of business?
Yes, Your Honor. So it's a couple of things. What I mentioned, and this is discussed nicely in both of the amicus briefs, but if every contractual arrangement or every enumerated instrument is required to be run through this list, then certain notes and certainly bonds, and I believe treasury bonds and certain other instruments, because they promise a fixed rate of return, they would be exempt from regulation. So that would leave a number of investors much more vulnerable, particularly for any number of instruments that are frankly scams that include a fixed rate of return as part of the inducement to get people to part with their money. And that's significant. The Securities Act was drafted broadly to encompass any number of schemes to basically spend other people's money, I believe is the language in Reeves. And the second piece of this that I think is really significant is ruling against the state in this case would really upset the status quo. The administrator has been applying Reeves since at least 2017, and nearly all securities transactions are already subject to state and federal regulation. So practitioners in the industry have been aware of and been following Reeves since it became law in 1990. So rejecting Reeves would be really a sea change for the industry as well as set Michigan apart from the rest of the country.
I see.
Are you asking us to endorse the Reeves test as the definitive test for Michigan?
So not in every instance, Your Honor. It would be as it relates to finding if the context requires finding that a note is not presumptively a security. So it would only be in the context of notes and for finding that if context requires otherwise.
Yes, but, all right, so help us, right? Opinions for the future. How do we draw the line as to when Reeves should be used and shouldn't be used to help in the context?
So it would apply for, and maybe I misunderstood the question, it would be the test for notes, but it would be the test for determining whether the context requires finding any note is presumptively a security or rebuts the presumption that it is a security. Does that address your question, Your Honor?
Well, I'm still trying to figure it out. You didn't make me more confused, but I'm not sure I figured it out myself.
So I think the answer is yes, it would be the test, but in a fairly, I don't know about how narrow, but a somewhat narrow set of circumstances. So it would be the test as it relates to notes. If something is an investment contract or if it were a contractual or quasi-contractual arrangement under the risk capital test, the court might look at other factors and circumstances, as Michigan courts have always done, looking at the economic realities of a transaction.
Do we owe any deference to the administrator on this?
Yes, I would say just in general. There is deference to be owed to the administrative agency and the administrator, and I would also point to the legislative mandate in section 2608 sub 2 that the administrator maximize uniformity between state and federal securities regulation. I think in addition to the deference owed to the director, that also suggests some deference and persuasive value at a minimum to the federal law in this area as well.
Does the context, should we look at I think it's been referred to the risk capital test and the other specific inclusions and exclusions from the laundry list? Is that statutory context that we should look at after applying the Reeves test? Is that what you're suggesting?
No, so that would come before looking at the context because that language would be used to determine if an investment instrument is a security in the first place or is presumptively a security in the first place, and then the context would be used to analyze whether or not that presumption should be rebutted.
So it factors into the Reeves test, and it would be then different, I guess, than the federal courts as the federal courts have applied it, because that's not factored into the federal test, right? Those provisions don't exist under the 33 Act or the 34 Act.
So they're not in the federal statute. I don't know that they're not applied in federal courts because a number of these tests have been adopted under federal law through case law. So I don't know that it's something that the federal courts don't consider, but certainly it's not in the federal statute. I don't know if that answers the question to your satisfaction.
Well, I've been wondering this language, which again appears in the federal statute about the context otherwise requiring, and then it's referred to as what the statutory context. And it has, led to sort of these interesting developments in the federal law. But I'm just trying to figure out where the things that are added in the Michigan statute factor into the analysis. And when I look at language that says unless the context otherwise requires, I sort of read that language to mean statutory context. In other words, not context in the outside world or factual context, but whether, this is the definition that applies unless you're looking at a specific provision where the context would require something else. Am I getting off on the wrong track?
I would disagree with that, Your Honor. I think the unless context requires otherwise language is meant to refer to the economic realities of the transaction, and I think in this case, or under this statute, it can also be used to look at federal law because of the mandate in 2608 directing maximizing uniformity with federal
So you
law.
can look sort of all over the place. Look wherever you want. You can look at the statute, you can look at the economic realities, you can look at the evidence, you can look at other statutes, federal statutes. Is that sort of your position?
Broadly, yes. I would say in this case, the Reeves test would really operate as a limitation on that because it sets out the factors that a court can look at in evaluating a note. But broadly, yes, my position would be that unless context requires otherwise is meant to refer broadly to the economic realities of the transaction, and then the risk capital test and all of those factors are meant to establish whether or not an instrument is in fact presumptively a security.
So what would be wrong with an approach that sort of let you have that broad-ranging look when determining whether the instrument is presumptively a security, and then looking at the rest of the statute as sort of statutory context? That's how I read. I think Reeves did something analogous in looking at statutory exemptions. I mean, some of these would be exemptions, some of these would be specific inclusions in the statute. We've dealt with other statutes where the legislature defines something and then gives us a laundry list afterwards, and then some of the things on the laundry list don't seem to meet the general definition, so it puts us in we have to decide sort of between the general definition and the specific list. I'm trying to fit this, maybe it's a round peg into a square hole, but I'm trying to fit this statute in that way and figure out if Reeves does apply, why can't it apply on the presumption side, and then look at these provisions as the statutory context. The concurrence, the Rehnquist concurrence in Reeves talks about toward the end, you don't need to go beyond the statute. Why do we need to go beyond this for that context to determine if the context otherwise requires?
So I believe one of the reasons, again, and I don't mean to just keep pointing back to the same thing, would be the mandate to look to federal law. That's certainly a direction from the legislature to look beyond purely the Michigan statute, because it's a directive to look at federal law.
Well, it's for the administrator to try to make the law or interpret the law in a uniform way. I don't know how far that goes in terms of the courts, but there's something there. I'm just suggesting that this statute's different than the federal statute, and we have to sort of, even if we're going to incorporate Reeves, we have to figure out where it fits in, and it's complicated. And so anyways, I don't want to keep going round and round in circles, but I've been trying to figure that out, how if we did apply Reeves and the family resemblance test and the earlier part of this analysis, and then look to the rest of this statute, which is maybe it's just because the legislature did it this way. It is sort of tacked on to the end of this big paragraph, almost like they wanted us to look there next.
Well, I think it was added where it was added, and it's written as broadly as it is because of the broad scope with which the statute is intended to have. The intent behind it was to capture any investment or any instrument or any transaction that is intended to be an investment. So I think it's written broadly to cover as wide a range of possible investments as possible. So I think that's really in looking at the context, I think it's important to consider the background that the statute is intended to be written and interpreted as broadly as possible.
It's, when you say broad, our job is to give it a reasonable interpretation to figure out, figuring out the scope. Obviously, it doesn't include everything, or else we wouldn't be here trying to figure out what things were included and what things are not. But okay, thank you for your answers.
Well, if there are no further questions, I would just leave the court with our request that it deny leave. Thank you.
Thank you.
Counsel, what's wrong with my, maybe it's convoluted, maybe it was opaque, but attempt to make sense of the statute?
So, I think that the first thing I would point is, I do agree with opposing counsel that unless the context otherwise requires is referring to the economic realities of the thing we're talking about, whether it's an investment or not investment in the context of a
Does that
note.
come from Reeves, or does that come from other federal court decisions?
I believe that's one of the general principles that you kind of see in a lot of the opinions. I know that the Michigan courts have all, Breckenridge and Sorgenoid kind of all started with that of, securities statutes are meant to regulate investments.
It doesn't, and I have to confess, I didn't read all the cases. There's lots of cases on this around the country in the federal courts and other states, but it doesn't seem to be the uniform approach to these context clauses, is it?
I think that I have, throughout litigating this case for the past couple of years, I have learned that uniform can mean very different things, and this seems like a less than uniform.
There's a case called Ruffinact versus O'Halloran, a Third Circuit case.
I am not
1984.
familiar with it.
It says, both the House and Senate provisions were intended to direct that the ensuing definitions were to be used throughout the statute unless the text of the act expressly or another section of the statute implicitly made them inapplicable to that section, talking about the 33 and 34 acts and the context clauses. Am I barking up the wrong tree? I've been looking at the plain, I'm a textualist, originalist for the last 11 years, trying to figure out, do we just go out into the broader world and judges and regulators get to look?
So I don't think it's quite that expansive. I think that the goal of this is we're looking at business transactions, right? Are these, and will you just focus on notes? Are these notes reflecting commercial loans? Is it a note securing I have a mortgage, I have a note that mortgage secures? That's not a security because it's a loan, and courts have said that security statute wasn't intended to regulate loans, it's regulating securities. And so I think that the economic realities is focused on looking at the transaction at issue, not the atmospherics of the broader world. But that being said, I think that even if that phrase is focused on the factual context of the investment or transaction we're talking about, that doesn't negate the fact that courts read statutes as a whole, and the statutory context, the text, structure, history, policy, practice, all still factor into statutory interpretation. It doesn't negate the principles of statutory interpretation, and so I would say that even if, unless context otherwise requires, is focused on the nature of the investment, we still look to the words of the statute and the statutory context to guide the court or guide parties in understanding how to analyze the economic realities of a situation and what economic realities tilt into the world of securities and which don't. And I think that's how we see these tests having worked throughout.
I just have a question for you. I just want to follow up on basically what Brother Counsel had indicated, and in the sense that this would be a real sea change and that it would make Michigan kind of unique to other states. Can you address that basic concern that this would create a dramatic upheaval and that this would be kind of an aberration to other states?
Yes, Your Honor. So unsurprisingly, I disagree with Brother Counsel for several reasons. First, I don't think there's any evidence that that's true based on the last 40 years. Michigan has had this language on the books. Michigan courts applied the risk capital 5-factor language from the late 80s and the early 90s, and that hasn't changed. And despite that being the binding governing case law of the state, we haven't seen an uptick or an unleashing of securities fraud. I think that there's no evidence in the record, there's no evidence in the case that the incidence rate of securities fraud was any different before or after before or after Reeves. And, you know, with respect to, this would be a sea change, I can't speak for what the administrator has been doing, but binding judicial opinions from the Court of Appeals stating that the risk capital factors are the factors for analyzing whether a note is a security has been on the books for, at this point, 34 years. And so given that, I don't think that it's quite the sea change that it's purported to be. I think I would also point out, as Justice Welch noted, one of the amicus argued that, well, these cases would achieve the same result under Reeves or the risk capital factors. They use that to argue that, well, hey, it doesn't make a difference and Reeves comports with Michigan law. I would look at the inverse. The risk capital factors might not be quite as bad as they're put out to be, given that they would reach the same result as Reeves in those cases. And just to sum that up.
Quickly.
Sorry.
That's all right.
At the end of the day, those are all policy considerations that are better directed down the street than to this court. This court is supposed to be focused on the plain language, and I just want to reassure you that I don't think it's quite as the sky is falling as it's made out to be. The last thing I want to say is, Justice Viviano, I want to, as your former clerk and on behalf of your former clerks, I want to say thank you for your service as a justice.
Thank you very much.
Thank you both. The case will be submitted.